Ayan. Sige. Let's start. We're done with the first chapter of our topic in sales. Hopefully we can pick up the pace. But for now, we'll have a short discussion lang, I think, because the chapters are very short. So let's start with the capacity to buy or sell. So when we talk about the capacity to buy or sell, we're talking about the legal capacity of a person to buy or to sell. Under Article 1489, all persons who are authorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. Under paragraph 2, where necessaries are those sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price. So what does Article 1489 says? It states that all persons, whether natural, meaning tao talaga, natural person, juridical, meaning partnership, corporation, cooperative, having the cloak of a natural person who can bind themselves, have legal capacity to enter into a contract of sale. Into a contract of sale. Now, I think I think you all know that the age of majority is 18 years old. So this is where a person can enter into a contract. Sir, how about kami, nung bata kami, bumibili kami ng mga kailangan namin. Okay? That is okay because a sale to a minor is what is voidable. Anong ibig sabihin ng voidable? When we say voidable, it is valid until annulled. Di ba? Yan ang voidable. Ang voidable contract is a valid contract until it's annulled. So if it's not annulled, it will remain and stand to be valid. So okay lang yung pagbenta sa minor. Okay? Exception, of course, those persons who are incapacitated. Okay? Under the second paragraph, okay, ang sinasabi nating necessaries, these are things that are important or necessary for the existence of an individual or a minor or a person without capacity to act. Meaning clothings, food, ayan. Yung sale na nangyayari dito kapag necessaries ang binenta, okay, the sale is valid. Okay, kahit pa the sale is made to a minor or to other person without capacity to act. Tandaan nyo, general rule, a sale to a minor is voidable, meaning valid until annulled. But under the second paragraph of Article 1489, the sale to a minor is valid or to other persons without capacity to act if the sale would involve necessaries. Okay? Yung mga importanteng bagay. Okay? Now what are the persons considered to be, or who are the persons considered to be incapacitated? There are two kinds of incapacity. Number one, we have the absolute incapacity. Number two, we have the relative capacity. Okay? So number one, when we say absolute capacity, okay, that person cannot enter into a contract of sale. Okay? Ibig sabihin, legally speaking or capacity-wise speaking, he cannot enter into a contract. Okay? And this would involve minors, demented persons, or insane persons, or deaf and mute who cannot read and write. Okay. The sale to them is either voidable or unenforceable. Okay? Sa minors, sa demented, they are voidable, but sa deaf mute, they are generally voidable, meaning they are valid until annulled. Okay? The second one is relative incapacity. One cannot buy certain property. One good example of this na wala sa listahan under Article 1491 ng Civil Code of the Philippines is sale to a foreigner. Okay? Foreigner ang gagamitin natin, pero sa batas kasi ang tawag sa kanila alien. Okay? Baka kasi iba ang notion nyo kapag alien. Okay? Alien ang tawag sa kanila. Okay? A sale of a land to an alien or to a foreigner is not allowed. Okay? A foreigner or an alien cannot own a land or a real estate in the Philippines. Pero, pero, madaming foreigners na merong may-ari ng lupa dito and they use meron silang tinatawag na puppet. Ang tawag diyan puppet kasi nire-register nila yung land sa pangalan ng puppet. Itong puppet na to is a Filipino. Yan. Imbes na naka-register kay alien yung pangalan, naka-register kay Filipino. Okay, but take note, a foreigner or an alien cannot own a land or a real estate in the Philippines. Okay? Any sale made to an alien or to a foreigner is a void sale. Okay? Void yung sale na yan. Hindi voidable. Void yung sale na yan. Okay? It is as if no sale transpired or no sale occurred. Okay? Take note. Foreigner or alien, wala yan sa civil code. But there are a lot of problems regarding that. Okay? Examples of relative incapacity. Okay? In relative incapacity, cannot buy certain properties. Number one, the husband and the wife. Meaning, the husband and the wife cannot sell properties to each other. Because that is absurd, di ba? Mag-asawa na kayo, magbebentahan kayo ng lupa, magbebentahan kayo ng bahay, sinong niloko nyo? Di ba? Generally, there is what we do not call it conjugal property, we call it community property. When under the family code, okay, when there is no marriage settlement agreed upon by the husband and the wife, okay, their marriage settlement is presumed to be absolute community of property. Okay, meaning the husband and wife, all of the properties acquired by the husband and wife during their marriage belongs to them both. Okay, so lahat yan pag-aari nilang dalawa. Okay, kapag magbebentahan sila, it's absurd because they own it both. Silang dalawa may-ari nun, magbebentahan kayo. Okay, this is put into law by the Congress because it will avoid prejudice. When I say prejudice, damages to third parties or third persons. Diba? Let's say for example, si husband merong utang. Okay, hindi niya mabayaran yung utang niya. Okay, ngayon, isa sa remedies ng creditor is to go after his properties kung wala siyang pera. Ngayon, si husband, since nakita niya na baka gano'n ang gawin ni creditor, ginawa ni husband, binenta niya yung property niya kay wife. So, wala na yung property sa husband. So, wala nang makukuha si creditor. So, yun yung sinasabi natin to avoid prejudice or damage to third persons or to third parties. Okay? Kaya husband and wife. Take note. Okay? This also applies to common law relationships. Sir, attorney, ano ibig sabihin ng common law relationships? Those persons living together without the benefit of marriage. Meaning, in short, in a colloquial term, it means live in. It also does not apply. It covered din siya ng relative incapacity. Why? To avoid prejudice to third parties or third persons, di ba? Kung yung ka-live-in mo may utang, para hindi makuha yung property niya. Let's say for example, yung sasakyan niya, binenta niya sa iyo, naka-live-in na yung property niya, o di wala na ngayong mahabol si creditor. Okay? Yun yung iniiwasan ng batas. Okay? This proscription or prohibition originated from prohibition on donation. Okay? Ang prohibition on donation, husband and wives cannot donate to each other. Mainly because it's absurd pa rin. Di ba? Kung yung magbenta ka sa asawa mo is absurd, mag-donate ka sa asawa mo is absurd because you basically own you both own the property. Okay, ba't mo pa i-donate kay wife or kay husband? Okay, kaya bawal din na mag-donate si husband kay wife or si wife kay husband. Ganon din sa common law relationship, bawal din ang mag-donate. Okay? Sir, paano yun? Pang anniversary namin, mag-gift ako sa sa wife ko, sa asawa ko. Okay, it's okay. It's okay. Okay lang yung mga ganong gifts. Okay? What the law is guarding or what the law is trying to enforce is to avoid any possibility of prejudicing creditors or third parties. Okay, kasi hindi mo siya maiwasan. Okay, yun yung sa husband and wife. Take note, this relative incapacity is covered by Article 1490 and 1491. Okay? Wait lang. Number 2, guardian and the property of persons under his guardianship, or guardian in the property of his ward. Ward kasi ang tawag. Why? Because you may exert undue influence on your ward. Di ba? Ba't mo bibilhin ba't mo bibilhin yung property ng ward mo? Di ba? Ikaw ang nagmamanage niyan. Ikaw ang nag-administer niyan. Okay? Itong scenario kasi na to, let's say for example, the minor was left with the estate or the properties of his parents who both died. Of course, the minor cannot manage and administer the properties of his parents who are now dead. Okay, wala pa siyang legal capacity kasi minor pa lang siya, below 18 pa lang siya. Okay? Ngayon, kung mangyayari yung nabibilhin ni guardian yung property, baka merong nangyayaring hindi maganda. Baka naman tinitake advantage ni guardian yung fact na minor pa yung may-ari ng property, kaya niya kinukuha lahat ng property ng minor. Yun yung binabantayan naman ng law under this situation sa second example ng relative incapacity. Okay? And then, agent and the property under administration or sale has been entrusted. Of course, ganun din. You're an agent basically because you are either, if it's an agency to sell, you are tasked to sell that property. Hindi dapat ikaw ang bumili niyan. Okay? Hindi ikaw ang bibili niyan. Kapag si agent ang bumili ng property ni principal, that is void. Okay? Except if the principal consents to that sale. Kung pumayag si principal. General rule, kung si agent ang bumili void except principal consents. Okay? Executors and administrators and property of the estate under administration. Okay, para makarelate kayo. Okay? Let's say for example, Mr. A. Mr. A died. Okay? A could either die intestate. I think I already mentioned intestate and testate before. Intestate and testate. Okay? When we say testate, testate. When we say testate, there is a will. Anong will, sir? There is a last will and testament executed. Okay, ibig sabihin si Mr. A, bago siya namatay, nakapag-execute siya ng last will and testament kung kanino mapupunta yung mga properties niya. Okay? Kapag intestate naman, walang will na na-execute. Ibig sabihin, si Mr. A, hindi siya nakapag-execute pulos ng kahit anong last will and testament. Okay? Yun ang difference ng testate and intestate succession. Okay? Ngayon, kapag testate, meron tayong tinatawag na executor. Ibig sabihin sila yung nag-execute ng last will and testament. Okay? Of course, hindi naman pwedeng si Mr. A kasi patay na si Mr. A, hindi siya mag-execute. Yung nilagay niya sa last will and testament na executor. Either yung kapatid niya, yung pinsan niya, yung close relative niya. Okay, yun ang executor. Okay? Ang administrator naman on the part of intestate. Okay? Na sila ang titingin or mag-administer ng properties. Okay? Ngayon, itong dalawa nito, executor and administrator, they cannot purchase the properties under their administration because of the possibility of exerting undue influence. Di ba? You are the one executing or administering the property. Pwede mong ibenta yan at lower cost to you. Di ba? And that will be an abuse of your authority as an executor or administrator. Okay, and that may prejudice the heirs who are supposed to succeed or who are supposed to inherit the estate. When we say estate, to clear things out, when we say estate, ito yung lahat ng properties. Okay, lahat ng properties ng isang deceased o yung namatay, si Mr. A. Lahat yan ng properties niya. Lahat yan minamanage at ina-administer ng isang executor or administrator. Okay? Kung na-execute na yung will, na paghati-hatian na, okay na. Okay? Pero habang under the administration or management pa lang ng executor and administrator, hindi pwedeng bilhin ni executor or administrator yung property under their administration. Siguro kung napaghatian na, distribute na sa mga herederos, sa kanilang mga heirs, mga rightful heirs, at binili ni executor at ni administrator, pwede na siguro. Okay? Basta tapos na yung pagiging executor at administrator nila. Okay? Number 5, public officers, employees, and property. Of course. Diba? Public officers and employees and property of the state. But there could be an exertion of undue influence. Being the public officer and employee of a government agency or GOCC, okay, pwede mo lang naman i-facilitate that property can be sold to you. Okay? There could be an exercise of undue influence or exercise of abuse of authority. Okay, kaya bawal. Okay? The next one is justices, judges, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with administration of justice and property and rights in litigation. So, bawal nilang bilhin ang isang property under their courts. Let's say for example, Judge A, okay? Judge A, meron siyang case na hinihear sa sala niya. Okay, at nakonsuladahan niya yung property, hindi niya yun pwedeng bilhin if it is under litigation. Pwede niya yung bilhin before na merong ma-file na case or after nung case. Okay? Pero wag yung during litigation. Okay? This also applies, take note, this also applies to attorneys. Yung mga private attorneys or private counsels. Pati sa kanila nag-a-apply itong prohibition na to. They cannot acquire the properties of their clients that are pending litigation. Okay? Hindi nila pwedeng acquire yan. Kasi, pinaglalaban mo pa yung kaso, ongoing pa yung case, tapos bibilin mo na. Okay? That is unethical. Okay, that is unethical. But if prior to the start of the case or prior to the case being filed, nabili na ni attorney yan, okay lang yun. Walang problema doon. Ang titingnan nyo lang under number 6 is the property pending litigation. Okay? Kasi merong influence na pwedeng maging factor kung bakit ganun ang nangyayari. Okay? I hope that's clear. Those are the persons with relative incapacity. Ayan, Article 1490, actually, I have discussed this earlier. The husband and the wife cannot sell property to each other. Di ba? I have said that kanina. Except, ayan, when a separation of property was agreed upon in the marriage settlement, when there's been a judicial separation of property. Now, para maintindihan nyo ng gusto, okay? Imagine this, bago kayo ikasal, usually, actually, kasi sa mga mayayaman kasi lang ito eh. Okay? Hindi natin ginagawa actually dito sa probinsya. Kapag ginawa mo yan, ang sasabihin sa'yo, bakit sa tingin mo ang habol lang ng asawa sa'yo is yung pera or yung property mo? Ganun lang ang sasabihin nila. Okay, but before you get married, under the law, there is what we call marriage settlement. There are 3 types of marriage settlement. You have number 1, absolute, yung discuss ko kanina, absolute community of property. Number 2, you have the conjugal partnership of gains. Number 3, you have the separation of property. Yan na, ito na yun. Kapag absolute community of property, kapag wala kayong pinag-agrihan nung kinasal kayo, ibig sabihin, nung kinasal kayo, diretso kasal, wala nang usapan regarding marriage settlement. Okay? Then, your marriage settlement is absolute community of property. Meaning lahat ng properties acquired or na idadala nyo sa marriage nyo is owned by both of you. Okay? Ang conjugal partnership of gains naman, lahat ng properties and cash na magigain nyo during the marriage is under both of your both din sa inyo. Ang difference lang niya kasi ito is pwede mong i-include yung properties na nasa iyo pa. Okay, nadadalhin mo sa marriage. Let's say for example, you have your house and lot, your own house and lot na you'll bring into the marriage, then that could be part of absolute community of property. Yung separation of property naman is totally, ibig sabihin, nag-agree kayo na totally separate ang property ni husband, separate ang property ni wife. Yan ang separation of property. Kaya kapag ang marriage settlement or marriage regime nila is separation of property, then they can sell properties to each other. Okay, husband and wife. Okay? When there's been a judicial separation of property, meaning, una, absolute community of property kayo, but then again, nag-petition ka sa court na i-declare na maging separation of property kayo, din pwede if there is a declaration. Okay? A judicial separation of property. Okay? Let me see. Yeah, they usually call it prenup. Okay, but they don't, parang sa atin kasi masyadong traditional or cultural ang pag-iisip pa ng, lalo na yung matatanda sa atin. Okay, that when we speak about marriage settlement or what you know as prenup, parang ang dating is parang insulto, kumbaga, na binabantayan mo yung properties mo. Ganun kasi ang dating. Okay, but especially in other states, in other countries, ginagawa nila ito talaga. Okay? Because there is what we call divorce in their country. Okay? Hindi mo naman kasi alam kung pera lang talaga ang gusto sa'yo ng tao. That's why they protect themselves with marriage settlement. Kasi nga, divorce is available to them. Sa atin kasi, wala naman tayong divorce. Okay? We have annulment, we have nullity of marriage, we don't have divorce. Okay? Divorce kasi yung pag ayaw mo na. Ayaw mo na. Ganun kasi yun. Okay? Dito sa atin kasi, pag ayaw mo na, hindi ibig sabihin maghiwalay na kayo or mapapawalang bisang kasal mo. Depende pa kung papasok siya sa annulment or pasok siya sa nullity. Magkaiba yun. Okay? Na-discuss ko na rin ito. Prescription applies even to common law relationships. Okay? Common law, di ba? Yung mag-live-in. It also applies to those. I hope that's clear. Article 1492, the prohibitions in the two preceding articles, meaning Article 1491 and Article 1490 in sa relative incapacity. Okay? They are also applicable to sales in legal redemption, compromises, and renunciations. Ngayon, example sa legal redemption, let's say for example, A owns a lot, di ba? Meron siyang lupa. Dito naman kay B. Okay, dito naman kay B. Ito yung lupa ni A. Ito yung lupa ni B. Okay? Ngayon, si A tsaka si B, sabihin mo nang para mas madali, mag-asawa. A, husband and wife. Okay. Under the law, okay, kapag gusto itong ibenta, okay, ang may right or ang may parang prior right to that property is the people owning the adjacent property. So kung sino yung mga katabing lupa, pwede nilang i-redeem or bilhin yung binibentang lupa. Ngayon, kung si A, sabi niya, bilhin ko yan, sabi niya, hindi pwede. Why? Because you are husband and wife. It also applies in this scenario na legal redemption. Okay? Okay, I hope that's clear. Okay, pero bakit mo pa ibebenta? This can be owned by both of you, di ba? That's just absurd. Sabi ko nga, that's just absurd. Di ba? Pero ang ginagawa kasi nila yan to avoid their creditors. Kaya nila binibenta. Okay? Ngayon, kapag namabaon sila sa utang, binibenta nila sa asawa nila. Kasi sa asawa din naman nila yun eh. Diba? Parang sa kanila na rin yun. Ganun kasi ang thinking noon. Kaya pinagbabawal na. Okay? Hindi naman sa ibang tao binenta, sa asawa naman. Di ba? Okay. Now, let's proceed. I hope that's clear. Okay? I hope that's clear. Now, let's proceed to another chapter. Effects of the contract when the thing sold has been lost. Ito, very simple actually. If at the time the contract of sale is perfected, the thing which is the object of the contract has been entirely lost, the contract shall be without any effect. Okay, I think you have read this na meron din sa oblicon nyo ito. Okay? The owner bears the risk of loss, di ba? The owner bears the risk of loss. Ayan, at the time of the perfection of the contract, sino pang may-ari? Of course, si seller pa. Okay? In that instance, kapag completely lost na yung thing, the contract shall be without any effect or the contract is void. Okay? An example of that is this. Let's say, for example, I have a house in Pampanga. Okay? I have a house in Pampanga. Now, I sold my house in Pampanga to Mr. B. Okay? I sold my house in Pampanga to Mr. B without the knowledge that my house in Pampanga is nasunog pala kagabi. Pero hindi ko pa alam. Okay? Pero nabenta ko na siya, nag-agree na kami. There is already a perfected contract of sale. Ngayon, kinabukasan, nung pinuntahan namin, sunog na. Okay? So, the contract is without any effect. Why? Because there's no thing, there's no object in the first place. Babalik ka ulit sa first article ng sales, yung elements, di ba? The consent, the object, and the cause or the consideration. May consent? Yes, may consent. The sale has been perfected. May object? Wala na. Wala nang object. Okay? Before, may object kasi akala ko meron pa yung bahay ko sa Pampanga. Not knowing na nasunog na pala. Pagpunta namin kinabukasan, wala na pala. The contract has no effect. Yun yung gustong sabihin ni first paragraph ni Article 1493. Okay? I hope that's clear. But, if the thing should have been lost in part only, the vendee, when we say vendee, the buyer may choose between withdrawing from the contract or demanding the remaining part, of course, paying its price in proportion to the total sum agreed upon. So, kung completely lost, ito ang completely lost without any effect. Kung partially lost or lost in part only, may dalawang remedies si buyer or si vendee. Ano yun? To withdraw from the contract or to demand the remaining part if pwede pa yung remaining part. Okay? If meron pa siyang paggagamitan, gusto pa niyang magamit, pwedeng piliin ni B na sige, ito na lang ang bibiling ko. Pero it must be proportionate to the price. The price must be proportionate to the total sum agreed upon. Hindi naman yung buo pa rin ang babayaran. Of course, in part lang din, in proportion. Okay, I think that's very clear. When we say lost, a thing is lost when it perishes, goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. Yun yung meaning ng loss under Article 1493. Okay? Article 1494. Actually, Article 1493 and Article 1494 are somewhat related. Ano yung difference niya? Look at this. Ang sabi dito, where the parties purport a sale of specific goods. Okay, sale of specific goods. Balikan natin yung 1493. If at the time the contract of sale, the thing, okay, the thing is lost. So 1493, we're talking about a thing. Okay, a thing, which is the object of the contract. Under 1494, we're talking about specific goods. Okay. which is different. Okay? And the goods, without the knowledge of the seller, have perished in part or have wholly or in a material part so deteriorated in quality as to be substantially changed in character, the buyer may at his option. So, meron na namang option si buyer. Okay? Kanina, ang option niya is kapag thing lost ay pag thing partially lost, can withdraw and demand the remaining part. Dito naman, we can have it avoided or as valid in all of the existing goods or in so much thereof as have not deteriorated, and as binding the buyer to pay the agreed price for the goods in which the ownership will pass if the sale is divisible. Meaning, parang yung sa second paragraph din na 1493, okay, partially lost, those that are still existing, that can be sold and that still of good quality may be sold to the buyer. Of course, the price should be proportionate to the total sum agreed upon and in the condition that the sale that the sale is divisible. Okay? When we say as avoided, ang tinatawag natin dito as pwedeng cancelled or rescinded. Okay? Of course, kung wholly lost na siya yung specific goods, of course, cancel mo na yung sale. Wala naman ng thing, di ba? Wala naman ng object. Okay? Or kung partially lost man siya at ayaw mo na ganun-ganun lang na kunwari 300 na goods ang in order mo and 200 yung nag-deteriorate or yung na-lost. Of course, ayaw mo na 100 lang, pwede mo siya i-cancel or i-rescind. Okay? Pero kung gusto mo naman na yung 100 lang, of course, pwede mo pa rin bilhin yung 100 lang. The price should be proportionate to the sum agreed upon. Okay? And provided that the sale is divisible. Okay? I hope that's clear. 1493 and 1494. Okay, yan lang yung effects in the being sold as being lost. So they are different. Take note of the difference. Now let's proceed to sale of real property in installment. We are through with the sale of personal property in installment. Tapos na tayo dito. I hope you can still recall this one. Na-discuss natin ito before. Sale of personal property in installment. There are remedies on the part of the, diba? There are remedies on the part of the seller. What's that? To exact fulfillment of the obligation. Number 2, to cancel. Number 3, to foreclose. To foreclose. Under this one, at least 2 installments ang nabayaran. Okay? So tapos na tayo dito, sale of personal property installments. Ito yung tinatawag nating recto law. Ngayon naman, let's proceed to sale of real property in installment na tinawag nating Maceda Law. Okay? Now, I have placed here the whole law itself. Of course, tinanggal ko lang yung last part ng law. Section 1, this act shall be known as the Realty Installment Buyer Act. So what is the purpose of this law? Okay, you can find it in Section 2. It is hereby declared a public policy to protect buyers of real estate on installment payments against onerous and oppressive conditions. Now, a law is passed based on the experience and the past transactions that was engaged to by the people themselves. And kapag the Congress has been made aware of the practices regarding the abuse of sellers, uh, on the part of placing conditions that are onerous and oppressive to the buyers are being taken on notice. And yan, kaya sila gumagawa ng batas. And yan yung sinasabi nating Maceda Law. Okay, why? Because these are real estate, these are real properties. Okay, ito yung mga lupa, mga building, house and lot. Okay? And hindi biro ang presyo nito, hindi rin biro ang number of years to pay nito. Under Section 3, okay, involving sale or financing of real estate installment basis. Of course, it includes residential condos, apartments, but it excludes industrial lots, commercial buildings, and sales to tenants. Of course, where the buyer has paid at least 2 years of installments, the buyer is entitled to the following rights in case he defaults. So, nung sa sale of personal property installment, ang may remedy or ang may right is si seller. Under sale of real property naman, si buyer. Okay? Kapag nakabayad siya ng at least 2 years of installment, the buyer daw has the following rights. The first right is to pay without additional interest the unpaid installments due within the total grace period earned by him. How do the buyer earn a grace period? The grace period is earned by a rate of 1 month grace period for every year of installment payments made. Since, okay, take note, since under this section, ang sabi natin, at least 2 years. Okay, so kung 1 month grace period for every 1 year installment paid. Okay, 8 to 2 years. So, ibig sabihin, meron siyang 2 months grace period. Okay? Pero at least to. Okay? Ibig sabihin, kung 3 years siyang nagbayad at nag-default siya, naka-earn siya ng 3 months grace period. Kung 4 years, 4 months grace period. Ganun siya. Okay? Meaning that within 2 months, okay, or 3 months, or kung ilang months man, wala ay pwede siyang magbayad nung default niya na installments, yung unpaid installments niya na nag-due without additional interest. Okay? Kasi masyado ng oppressive at onerous, burdensome kapag nag-default na siya and papasok pa yung interest. So, mas lalaki at lalaki yung utang niya. Take note, Maceda Law is enacted to protect the buyers of real estate in installment basis. Okay, kaya under the first right by the buyer, okay, the buyer earns a monthly grace period for every year that he has paid an installment. Okay, so he can pay within that certain grace period, whether 2 months or more, okay, without additional interest. Okay. There is a proviso provided that this right shall be exercised by the buyer only once in every 5 years of the life of the contract and its extensions. Okay? So let's say, for example, 10 years, 30 years na contract, okay? You can exercise this right How many times? 6 times. Okay? Because you can exercise it once every 5 years. So you can exercise it 6 times. So for the year 1 to 5, kung meron kang, kung nag-default ka dyan, you can exercise that. Okay? For 6 to 10, kung nag-default ka, pwede mo exercise. Pero kung 1 to 5, on the third year, nag-default ka, in-exercise mo, tapos on the 5th year, nag-default ka, hindi mo na pwedeng exercise yan. Okay? Yun yung sinasabi nating proviso. Yeah. Okay? I hope it's clear. What happens to the second right? If after the given monthly grace period, okay, kasi nga may na-earn kang monthly grace period, pero hindi ka pa rin nakabayad, the contract can be canceled. But before the contract is canceled, the seller shall refund the cash surrender value of the payments on the property equivalent to 50% of the total payments made. 50% of the total payments made. Okay? And after 5 years of installments, an additional 5% every year. But not to exceed 90% of the total payments made. Okay? So, kapag hindi ka nakabayad dun sa monthly grace period mo na na-earn mo, okay, as a buyer, okay, the contract may be canceled. But before the contract is canceled, okay, the seller must refund to the buyer. Ibig sabihin, ibabalik ni seller kay buyer yung cash surrender value ng payments dun sa property. Hindi yung cash surrender value ng property, cash surrender value of the payments on the property, which is equivalent to 50% of the total payments made. Of course, ang pinag-uusapan natin dito is the payments made, hindi yung value ng property. 50% total payments made. If after 5 years of installments, you earn a 5% addition to that cash surrender value. Okay, for the 6th year, may 5%. For the 7th year, may 5%. Take note, these are sales of real property in installment basis. When you sell a real property, mahal yan. Okay, mahal yan. Usually, fini-finance yan. Okay, ang financing term yan, either 10 years, 20 years, 30 years. Depende, of course, sa capacity mo as a buyer. Okay, kung ikaw naman yung milyonaryo, why not? Naman kaya mong bilhin in short span of time. Pero typically or generally speaking, malalaki ang terms niyan. Kaya ganyan. Ganyan siya binuo yung batas. Okay? I hope naintindihan niyan. There is also a proviso. Meron din siyang proviso. Provided that the actual cancellation of the contract shall take place after 30 days from receipt by the buyer of the notice of cancellation or demand for rescission and upon full payment of the cash surrender value. Take note, before ma-cancel yung sale or before ma-cancel yung contract, dapat meron munang, number 1, notice of cancellation or demand for rescission, and there is full payment of the cash surrender value yung discuss natin kanina. Okay? So, before siya ma-cancel, meron munang notice or demand for rescission. And, ang sabi niya dyan guys, and, ibig sabihin, kailangan notice or demand and full payment ng cash surrender value. Okay? Bago makancel yung contract. Okay? This is good on the part of the buyer kasi out of the payments or installment payments na nabigay niya, pag hindi niya natapos yung term na nag-default siya, at least meron pa rin siyang makukuha na babalik na value ng installment payment na binigay niya. Hindi naman yung ika-cancel na lang, wala siyang makukuha. Di ba? That's too oppressive on the part of the buyer. Di ba? To think na the sale is canceled. Ibig sabihin, the sale did not push through. Dapat sana ibabalik yung payments made. Pero dito, ang sabi ng batas, 50% of the total payments made. Granting na after 5 years of installment, may increase na 5% every year thereafter. Okay? Provided din na hindi siya mag-exceed ng 90% of the total payments made. Okay? So, itong 50%, pwedeng tumaas ng hanggang 90% or 85%. Kasi ang sabi na naman dito, not to exceed 90%. Okay? So, kapag hindi siya nag-exceed ng 90%, 90% lang siya, pwede. Okay? Down payments, deposits, or options on the contract shall be included in the computation of the total number of installment payments made. Diba? Minsan, we are required to make a down payment na sobrang laki. We are also required to make, aside from the monthly installment, we are also required to make 1 month or 2 months deposit, diba? In case na mag-default. Lahat yan ibibilang. Okay? This is advantageous to the buyer, and this provision is especially made for the buyer, in favor of the buyer. Okay? Take note, ang Maceda Law is enacted to protect the buyers of the real estate in installment basis. Because of the previous practice na onerous at burdensome ang conditions under sales of real estate against buyers. Section 4. Yung kanina, at least 2 years. Paano kung hindi umabot ng 2 years? In case where less than 2 years of installments were paid, the seller shall give the buyer a grace period of not less than 60 days. Oh, di ba? May grace period ka na not less than 60 days. Okay? From the date the installment became due. Okay? If the buyer fails to pay the installments due at the expiration of the grace period, the seller may cancel. Ito na yung pinag-usapan natin kanina. Under the Section 3, the seller may cancel the contract after 30 days from receipt of the notice of cancellation or demand for rescission. Take note, parehas dun sa Section 3, itong notice of cancellation and demand for rescission must be notarized. Okay, they must be notarized, meaning they must be executed under oath. Okay, under oath yan. Ibig sabihin, dapat sure si seller na meron siyang right, sure siya sa facts niya. Why? Because you are going to execute this under oath. Kapag hindi totoo ang mga sinabi mo dyan, you may be making perjured statements, you may be liable for perjury. You may be liable for perjury. Okay? Kaya siya under oath. Safeguard na naman yan sa buyer. Meaning, the seller cannot just abuse, okay, his right na magbigay ng notice of cancellation or demand for rescission. Okay? Dapat sure siya sa facts niya and willing siya na mag-execute under oath. Okay? Kapag hindi notarize or hindi notarized or hindi executed under oath ang kanyang notice of cancellation or demand for rescission, then hindi dito makakancel. Okay? Hindi makakancel yung sale. Okay? Ganun din sa section 3. Sabi dito, of the contract by a notarial act. Okay? Hindi siya makakancel. Okay? I hope that's clear. So kung at least 2 years, ang grace period na ma-earn niya is 1 month for every year. Okay? 1 month for every year. So kung 5 years siya na nakapagbayad, so meron siyang na-earn na 5 months na grace period. Okay? Dito naman kung less than 2 years siya, meron siyang grace period na hindi bababa ng 60 days. So pwedeng 60 days, pwedeng 70, pwedeng 65, depending upon the discretion or sa pag-usapan nilang dalawa. Okay? Basta hindi bababa sa 60 days ang grace period niya. Okay? Kapag hindi naman siya nakabayad, after ng grace period, pwedeng i-cancel na ni seller. Okay? Cancel na ni seller. Okay? Provided na after 30 days at may notice of cancellation and demand for rescission and notarize. Okay? Take note din, under Section 3, kapag kinancel mo, i-refund yung 50% of the total payments made. That's under Section 3. Under Section 4, okay, walang refund. Nakita nyo? Walang refund. Cancellation lang. Okay. Basta na-observe yung 30 days, na-observe yung notice or demand and yung notarial act, canceled yung sale. Okay? Compared to Section 3 na merong before na actual cancellation ng contract, dapat meron munang notice or demand and full payment of the cash surrender value of the payments on the property. Okay? Under Section 5, sabi dito, under Section 3 and 4, yung previous na discuss natin, yung at least 2 years. Yung 4 naman is less than 2 years. The buyer shall have the right to sell his rights. Take note, ha? The buyer shall have the right to sell his rights, assign the same to another person, reinstate the contract by updating the account during the grace period and before the actual cancellation of the contract. The deed of sale or assignment shall be done by notarial act. Take note, during the given monthly grace period or during the earned monthly grace period, madaming pwedeng gawin si buyer. Okay, of course, unang-una, yung gagawin niya na pwede siyang magbayad. Bayaran niya yung installments due, that fell due. Okay? Pangalawa, pwede niyang ibenta yung rights niya. Okay? Pwedeng iba ang magtuloy nung installment niya. Ibenta niya yung right niya under the contract and iba na yung magmamayari ng lupa. Basta willing silang ituloy yung installment or i-assign to another person. Yan yung pwedeng gawin ni buyer before mag-lapse or before mag-end yung monthly grace period niya. Okay? Or yung grace period niya. Okay? And before ma-cancel yung sale. Okay? So take note of that. The buyer shall have the right to pay in advance any installment or the full unpaid balance of the purchase price anytime without interest. Take note, without interest. And to have such full payment of the purchase price annotated in the certificate of title covering the property. Okay? In short, the buyer, kung may pera si buyer or kung madami na siyang naipon, he can pay in advance any installment. Let's say, for example, pwede siyang magbayad ng, kunwari, meron siyang pera to pay 5 monthly installments, pwede. Pwede. Okay, pwede niyang i-advance. Okay, this is without interest. Okay, or kung nakaipon na siya ng enough money to pay the whole amount, okay, to pay the unpaid balance or the whole remaining balance in the installment, pwede. Okay, this is also without interest. Okay, and to have such full payment of the purchase price annotated in the certificate of title. Now, we're talking about, ang sabi natin dito sa Maceda Law, ang binibenta is real estate or real property. And real property is evidenced by what we call a title, or yung iba ang tawag dyan, transfer certificate of title kung dati nang nabenta, or original certificate of title. Okay? Ngayon, ang sabi dito, kapag nag-full payment siya, pwede niyang i-annotate ito sa title. Meaning, pwede niyang ilagay. Ang annotate kasi, okay, parang ilalagay mo sa likod, at the back, ilalagay mo sa likod ng title. Na nakalagay doon na you have fully paid your balance or the purchase price. Yun ang sinasabi niya dyan, na ilalagay mo sa likod. I-annotate mo sa title. Ilalagay mo sa likod ng title. Why? Because sa likod ng title, kung nakita na kayo ng title, wala yung sample, wala akong sample. Ay, may mga title ako dito. But nonetheless, okay, hindi ko mahanap, magulo. Okay, but nonetheless, kapag titingin kayo ng title, tingnan nyo yung sa likod, may mga nakalagay doon encumbrances or annotations. Encumbrances or annotations. Doon nyo makikita kung naka-mortgage yung lupa, kung naka-loan, doon nyo siya makikita. Doon nyo rin pwedeng ilagay yan, yung full payment ng purchase price. Okay. Why? To facilitate the transfer in your name. Okay, kasi ang certificate of title, ang nakalagay dyan na pangalan, of course, pangalan pa yan ni seller. Kaya mo siya i-annotate sa title para ma-facilitate na yung transfer sa pangalan mo as the buyer. Okay? I hope that's clear. Any stipulation in any contract entered into contrary to the provisions of Section 3, 4, 5, and 6 shall be null and void. Take note that contracts are the laws between the parties concerned, whether dalawa kayong parties or tatlo, they are the law. Okay, kung ano yung nasa contract nyo. But take note also that contracts must adhere. Okay, contracts must adhere to the provisions of the law, meaning it must not be contrary to the law. In short, relating to this, hindi siya dapat contrary to the Maceda Law. Okay? Otherwise, kung ibang nakalagay sa contract nyo, that stipulation is null and void. Take note, guys. Baka malito kayo. Okay, buti lang naisip ko rin. Okay. What is null and void here? Is it the contract itself, the contract of sale itself, or the stipulation, or the provision itself. What is null and void here is the stipulation in the provision itself. Okay? The contract, if it can stand, remains to be valid. Okay? Except dun sa provisions na contrary sa section 3, 4, 5, and 6. Therefore, kung contrary siya sa 3, 4, 5, and 6, lahat yun null and void. Ang ifa-follow nyo is the Maceda Law. Okay? Maceda Law. I hope that's okay. Okay, I hope naintindihan nyo. Okay? What is null and void is not the contract itself. Okay, but the stipulation in the contract. Sabi dito, any stipulation in any contract shall be null and void. Okay, those that are contrary to the provisions section 3, 4, 5, and 6 shall be null and void. It is the stipulation that is null and void and not the contract itself. Ayan. So, we are done with the topics that covers 2 weeks. Okay? Yung capacity to buy and sell, and then yung Maceda Law. Okay? So, hindi pa tayo mag-quiz, just do the case studies that I have uploaded. Nag-upload ako dun sa both, check nyo dun sa capacity to buy and sell, tsaka dun sa I think week 2 and week 3 yan. Okay, nag-upload ako ng case study dyan. You should answer that one. Do you have any questions? None? Silence means wala.
None po, sir.
Answer. Okay.
Sir?
Sige, Mr. Rivera.
Sir, yung example niyo po pala kanina, yung sales ng yung sa yung bahay po na sunog. Paano pala sir kung ganun pala yung bahay at lupa pala yung binebenta? Tapos nawala yung bahay, yung house and lot worth halimbawa 2 million, nasunog yung house, yung lot na natira, paano yung proportion ba yun? Ganun,
Kung gusto mong bilhin ni buyer yung lupa lang, then why not? They should proportionate it according to the price. Depende sa facts na nangyari or dun sa facts na mangyayari. Okay? That is if gusto ni buyer na bilhin yung lupa lang. Okay? Kasi ang original na intention is to buy the house and the lot. Okay? Kung ayaw niya na lupa lang kasi gusto niya rin yung bahay, then pwede siyang ano yung nakalagay din? Withdrawal. Okay? Ganun. Or kung gusto niya pa rin bilhin yung lupa at i-push through, depende sa facts ng case, kasi wala tayong facts. Okay, depende sa facts ng case. Kung gusto niya, then pwedeng hatiin. Kung paano nila hatiin. Usually sa mga problems na ganyan, merong value na naka-allocate dun sa lupa tsaka dun sa bahay. Kapag may mga problems na ganyan. Since wala tayong facts, proper facts na given, hindi natin ma-determine kung paano natin siya hatiin. Pero kung ganun naman, let's say for example, sige, balik tayo dun sa ano. Ayan. For example, the land or the house and lot is sold for, let's say for example, 3 million, masyadong mababa. 5 million pesos. Okay. Let's say for example na lang na merong book value or historical value ang house na worth siguro yung house is worth paano lang ito estimates lang ito, hindi ito parang proper na values. Okay? Let's say for example, the house can be sold. Ang original na value ng house is 2 million at yung land is 2.5 million. Okay? Ngayon, kung ganyan na nawala yung house, okay, na nasunog, gaya ng example natin before, we can arrive at the proportionate amount. Diba? Kung paano yung pag-factor niyan, kayo nang bahala dyan sa computation, 2.5 over 4.5, ganyan ba? Yung pag-proportionate, times 5 million. Kung tama yan, okay, ganyan ang pag-proportionate. Okay, kasi yung value ng house is 2 million over 4.5 times 5M, di ba? Ganyan ang pag-proportionate. Okay ba? Tama ba? Hindi ako magaling din sa computation, ha? Ayan. Mr. Rivera, okay lang?
Yes, sir. Thank you po.
Depende. That's why it's very hard to answer questions without certain facts. Kasi maiba mo lang or meron lang isang fact na mag-iiba yung buong sagot. Okay? Kaya importante na lay down yung facts. Kung ito lang talaga yung facts na given, then you give the whole scenario. If ganito ang mangyari. If ganito ang mangyari. You give the whole scenario. Kaya nung exam natin, ganun ang mangyari. So just answer based on the facts given. Kung ano lang yung facts. Kung hindi clear yung fact or yung question kasi pwedeng it depends ang sagot, you put both answers. Okay? Pero wag mong sasabihin, ito pala. Okay? Sa mga napansin ko sa mga answer, never put I believe. Yan. Ang daming nagsagot na I believe. I don't care about what you believe. You give me what the law says. Okay? Wag kayong sasagot ng I believe. Kasi mortal sin yan sa law school. Because the professors are not asking for your opinion. They are asking for the application of the law. Sabihin mo lang, the law states, or under the law. Okay? Ganun lang. Huwag mong sabihin na opinion mo. Of course, that's your opinion, pero huwag mo lang sabihin. That's your understanding. Okay? Huwag kayong magsagot ng I believe, and huwag kayong magsagot ng it depends. Okay? There is another way of answering a question na ang sagot ay it depends. How? You make a qualification. Okay? You make a qualification. Meaning, gaya nung gamitin natin example ni Drexler kanina, okay? Na if the house is lost and gustong bilhin ni buyer, then this is the answer. If the house is lost and ayaw nang bilhin ni buyer, this is the answer. You put a however in between those statements. Meaning you answer in the general rule. Okay? Or in the normal answer. Huwag kayong sasagot ng it depends. Okay? Mortal sin yan. And also, reminder, wala ata dito pero wag kayong mag-submit ng case study, quiz, or exam na sa Google Drive. Okay? How can I access that? Merong password, merong kailangan na i-authorize nyo ako. And you can access that anytime. Diba? Yung sa Google Drive, you can access that anytime. Never submit an answer in Google Drive. And yung sa case studies nyo, I'm sorry if merong in toto na magkakaparehas, I'm sorry. Okay? I give my warning first. Sana wag nyo nang ulitin. You have 1 week to you have 1 week to prepare for that. That medyo madali pa nga yan. Okay? I just want you to answer in your own words. Answer independently. Okay? And if ikaw man, na sa tingin mo matalino ka, na tumutulong sa mga kaklase mo, I'm telling you, stop. Hindi mo sila tinutulungan. Okay? You're just allowing them na maging dependent sa'yo na hindi dapat. Okay? Kapag mag-board exam kayo, kanya-kanya yan. Okay lang, mag-review kayo, magkakasama kayo kung dyan kayo masaya or dyan yung nakasanayan nyo. But never, ever tolerate cheating. Alam mo yan sa sarili mo kung matalino ka talaga. You're not helping that person. Okay? Kasi if you really want to help that person review, help that person study. Don't help that person to cheat. Kahit pa case study lang yan. Okay? Of course, alam ko yan kasi may pinanggagalingan yung mga answers nyo. Nanggaling yan sa kayang sumagot ng tanong. And that I won't tolerate. Okay? Wag na wag niyong gagawin yan. Hindi ganyan ng mga bisak noon. Very competitive. Okay, although maganda yung brotherhood, yung sisterhood nila because they study together, they don't cheat. Okay, which you should not do. Yes, Mr. Felimar.
Sir, permission to speak po.
Sige.
Sir, tanong lang po sana namin yung grading system nyo po sa essay po.
Why?
Kasi para alam po namin kung paano mag-adjust ganun po sa...
No, if nakita ko nakaparehas na yan nung sagot ng isa, then I'm sorry, I'll give you a lower score. Let's say for example, yung pinakopya mo na una kong chinek, siya yung 10 points. Ikaw na last ka na check, siguro 5 points or 6 points. Depende na lang sa asar ko siguro. Okay? Kasi nung binabasa ko yung case study nyo, grabe. Meron yung isa, nilagay niya sa taas yung paragraph na lang sa baba nung isa. Meron yung isa, pinalitan niya lang yung words. Okay? That is cheating itself. That's prima facie evidence that's cheating. Sabi ko nga, no two persons think alike. Okay? Pwedeng parehas kayo ng idea, parehas kayo ng sagot, parehas kayo ng iniisip. But the delivery, the sentence construction, the paragraph construction, that will never be the same. Okay? So, it's not my fault na gano'n ang mangyayari sa inyo. If later on, makita ko na parehas ang sagot niyo. Okay? You have your own minds. You can construct your own sentences. You do it by yourself. Okay? Makita ko naman yan kung parehas talaga or hindi or nagkataon lang na parehas yung sagot. Pero never na meron magkakaparehas ng sagot. Okay? Mr. Amos. Yes.
Sir, ask ko lang po kasi yung ano po, ang feel ko po yung tinatanong po ni Fel po is about sa rubrics po ninyo. Parang ganun po.
About what? Yung sa pag-grade ko?
Yes, sir.
It depends actually. Meron kasi yung sumasagot na tama na and then nasosobrahan nila yung sagot nila. Yun may mga bawas ng points. Okay, but generally, if you hit the answer, generally 10 yan. Pero meron yung nagsosobra ng answer na tama na sana, pero nagsosobra, nagbabawas ako ng points. Okay? Questions? And if you cheated, siguro naman masaya ka na meron kang score. Okay? Na gradean ka. Okay? Kasi hindi naman sa'yo yung effort. Hindi naman sa'yo yung grade actually. Dapat hindi sa'yo yung grade. Pero meron kayong grade. Okay? Questions? Meron pa? Just don't do it. Do it by yourself. Okay? Hindi yung wag kayong masyadong mag-rely sa cheating. Actually, nung time namin kapag na-late ang prof ng 10 minutes or 15 minutes, wala kami in a position to ask for extension. Okay? We just answer kapag bigay, mag-answer kami. Okay? And don't ito kasi ang mahirap din sa system natin sa LMS. Medyo late siya na nag-give. Okay, although meron kaming sineset na time na mag-give siya, let's say for example, mag-give siya ng 6 o'clock, hindi siya kaagad nag-give. Kaya siguro nade-delay minsan. Actually, last sem pa yan, ganyan na nangyayari sa akin na nade-delay siya na mag-give. Okay, so may apologies for that. Siguro next time I can make an extension ng 5 minutes. Let's say for example, 6 to 7:30. Pwede naman dun merong grace period na 5 minutes. I can put 5 minutes on that para kung sakaling mag-lag or mahirapan kayo sa pag-submit ng answers nyo. Yun siguro. Para siguro. Nakikita ko din kasi mahirap din kapag pukpukan na nagpapasa kayo. Hindi kayo makasubmit. Okay? Pero isa pa ito na napansin ko, mayroong mga nagsasubmit. Okay? Yung sagot nila na sinubmit nila is ibang-iba dun sa pinost nila sa comment. Halata na yung sagot nila sa comment is nanggaling na sa iba. And that is very obvious na cheating to me kasi yung sagot nila ibang-iba dun sa original na answer. Okay, and sinasabi nila na ito daw yung sagot nila, hindi yung nauna. Should in your part, that is pangloloko eh. Di ba? It's not good. It's not good. It's not a good practice actually. You have time to submit that. And ganun ang gagawin, di ba? Late pa na sinubmit yung comment na yun. Late yung sinubmit and kompleto siya ng sagot. Actually, lengthy yung sagot niya sa comment. Pero yung sagot niya sa answer dun sa sinubmit niya, mga 1 sentence lang. Okay, yung iba hindi pa niya nasagutan. That's very questionable on my part. Kasi nasagutan mo siya na konti-konti tapos biglang magsasagot ka ng alam mo na lahat. Diba? Very questionable. Okay? And we on our part, we don't want you to cheat kasi alam namin later on na you will rely only on yourself sa board exam. Okay? Whether you want that or you accept that reality or not, that is the reality of it. Maganda yung ngayon pa lang nasanay na kayo to be independent. Okay, you can work together, you can study together, but not during quizzes, not during case studies, not during exams. Okay, doon lang hands off. Okay, yun na lang siguro yung respect na lang siguro sa akin kung meron na hindi kayo mag-cheat. Okay, yun ang pakiusap ko. Pakiusap ko lang naman. Sana. Okay, sana lang. Pag mag-check ako ng case studies, sana wala masyado. Okay? Anything else? Wala na? Let's call it a night. Okay? Next meeting, obligations of the vendor. Okay? Sana makarami din tayo, matapos din natin. Okay? Good night. Good night, everyone. Good night.
Thank you, sir.
Thank you, sir.
Thanks, sir.
Thank you po, sir.
Thank you,
Bye
Thank
po.
you, sir.
Thank you, sir, so much.
Thank you po.
Sir Eric. Ayun, lumalis na.